Ms Matthews, we think it will be helpful to us as well as to Ms Delaney if you do put in writing exactly what you say happened about this. Would you do that, please, by 9 o'clock tomorrow morning? Send whatever you produce by email to our clerks. In addition, I don't know whether you have to do other formal filing on CE filing or anything, but if you send it that way, we'll see it, and of course to Ms Delaney as well.
Of course, my lord, yes. and what we're seeking to do is to demonstrate the danger. And I will just briefly answer the question that Your Lordship raised before the break and come on in a moment to make it good. This was a point of the judges, not raised and not argued by Deutsche Bank. And with respect, rightly, because they know it's wrong too. So it's not surprising that they did. But I'll come back to give you the references to that and so on and make that good. Yes. And so what I was demonstrating by reference to the emails which we have in the supplementary volume 3, tab 24, at page 717, was that in August, 26th of August 2009, the at item 3, the Debevoise were asking for the witnessing, and that what clearly happened was that Mr Vik did not sign a second time, and nobody is suggesting that he did, and therefore the path that the learned judge took in reliance upon that, in the conclusion which she then reached about having, she concluded, deliberately withheld the copy that Mr Vik must have realised was the later version because he must have signed the second version, was itself not correct. It is clear, therefore, that Mr Vik did not sign any version 6, which had the new dates of 2009 rather than 2008. And if we go then to page 716, we see that in the second main paragraph, there is the point raised by the general partner, or by Debevoise on their behalf, that they are unable to use the September 2008 effective date for their own accounting and recording purposes, for the various reasons they're set out. And it's for that reason that instead of the 2008 date, they want to switch it to 2009, albeit that they can accommodate the clause which we eventually see in 2006, which recites the transfer in 2008 as between SHI and Delgoa, but for the purposes of the partnership refers to 2009. But it is clear, with respect to the learned judge, from the judgment, the passages that we looked at, that the judge had seriously misunderstood the evidence that she received and attributed very serious consequences to her wrong understanding of what the documents showed. She put a lot of weight on the fact that Mr Vik had signed the documents twice, and must have known and realised there was a second later version which he must have retained after signing, but chose only to disclose the first version in order to mislead. And the second version had of course emerged from the Norwich Pharmacal Order directed at the partnership itself, and there is no evidence that Mr Vik ever saw or knew anything about version 6. And yet the judge concluded that he deliberately failed to disclose that version and then drew the serious negative conclusions that she did from that as to his credibility. And then just moving from the two signature point to the second, or the twice signed point, to the second point in relation to these documents, which is the manuscript alterations. And as to those, once you establish that there is no evidence that Mr Vik had any involvement in version 6, for which his version 5 signature was simply reused, there is no evidence on which the court could properly have reached any conclusion based on the manuscript, and in any event, the conclusion which the judge reached as to the manuscript amendments cannot itself be sustained on the evidence. Deutsche Bank, as well as Mr Vik, knew at the time of the Part 71 cross-examination that the transfer of the legal interest as between Carlyle and SHI was not completed until later than September 2008. That was a matter of public record in the London Gazette. So no one was actually being misled. The issue was not over when the general partner had signed, but as to when the transaction had taken place as between SHI and De La Goa. And in fact, the formalities in relation to that were, as we can see from 720 to 719, not completed until September, October 2009. The fact that the version 5, which we're looking at tab 20, had the 2008 effective date in it back in 2009 and had not been later inserted for the purposes of disclosure in 2015 was apparent from, or at least consistent with, the email exchanges between Per Johansson and Debevoise. If we go back again to tab 24, page 716, the paragraph that I was taking you to a moment ago, second main paragraph on the page, we have spoken to Carlyle regarding paragraph 4, the date of the agreements, and we believe September 2009 is the appropriate date. Carlyle has no problem with any agreements that Sebastian and De La Goa have between themselves as the effective date of the transfers. That date can be September 26, 2008, or any other date that the parties have negotiated, and nothing specified in these transfer agreements will change that arrangement. So the upshot is that Carlyle is unable to use the September 2008 effective date for their own accounting and reporting purposes. So what was being proposed to Carlyle by Mr Johansson was a 2008 date in 2009, and therefore there's no basis for suggesting that the 2008 date was some kind of invention in 2015 in the context of disclosing these documents, or that there was a deliberate amendment in 2015 rather than it having been there in 2008. And in any event, all the changes were organised by Mr Johansson through exchanges with the general partner, to which Mr Vik was not a party. But yet, if we go back to the judgment, at paragraph 94, page 204 of the core, Her Ladyship says, in my view, such an inference, namely the inference she's identified at paragraph 93, that Mr Vik had only retained the 2000 and the version 5 document and the one recording the earlier versions of each of these dates with the dates which accord with his case, rather than the later version which is as adverse to his case. In my view, such an inference is wholly implausible, and there is no explanation for the manuscript amendments other than that they must have been made deliberately, i.e. she is suggesting in 2015 for the purposes of disclosure and in order to mislead in the context of the Part 71. And yet all the evidence points to their having been made in 2009, because this was the date Mr Johansson wanted, namely Mr Johansson wanted the 2008 date in to reflect the date of transfer as between SHI and De La Goa, but the general party was insisting on the change from 2008 to 2009.
When she says manuscript amendments, she simply means manuscript insertion of the date, does she?
Yes. Yes. The manuscript is the date.
Yeah, there's no. I'm just looking through it, there are no other amendments in manuscript. It's simply the date is written in manuscript.
Yes.
Yeah.
And
My lord, I'm not sure that's right, but we'll deal with that.
All right. Well, that's what I was trying to find out. But you tell me if I got it different later on.
And in many respects, this does appear to have been a creation of the judge herself. And in particular, the twice signing element of it. In Mr. Hart's first affidavit, he had dealt with this, and obviously I emphasise this is bits that had been set aside, as it were, because dropped off the charge sheet. But the way he had dealt with it at page 421, paragraph 160, and in particular at F and G, had not...
Sorry, which bundle are we in for that?
I'm so sorry, this is a supplemental bundle 2, that's tab 12, paragraph 160, talking about the version 6 obtained from Carlisle, and pointing out at 160F in particular that the signature pages of SHI and Delagoa had not changed. So Deutsche Bank were alive to this fact, that there weren't two versions signed by Mr. Vik, there was only one. Neither Deutsche Bank's skeleton for Mrs. Justice Moulder nor in oral opening did they advance this argument. In their written closing, which you have at tab 17 of the same bundle, at page 607, paragraph 295, they set out their case about the seeking to mislead, and they do not in there suggest that Mr. Vik had signed twice. And in their oral closing, they mentioned again fabrication, but not this particular detail or argument, which you have in two places in the transcript of the closing. Page reference, supplementary bundle 1, tab 7, at page 230 and 295, which is in the internal transcript for day 9, page 3 at line 22, and pages 139, line 16 to 140, line 12. So it wasn't a case advanced by Deutsche Bank, and therefore obviously not one that we met. It demonstrates both the danger of using points like this in order to reach important, as the judge several times pointed out that to her it was, decisions on credibility on, frankly, peripheral points, or indeed technically points that weren't really there at all.
Well, is that quite
quite right, Mr Matthews. I'm just looking at paragraph 163 of Mr Hart's affidavit, where the case that's being made out is that it said he didn't execute the draft Carlisle deeds in the form that was provided. Someone amended them before he signed them. Surely that's a case being made out that he signed something different from what he produced.
So somebody amended them before he signed them.
Yeah. That's what's said by Mr Hart, rightly or wrongly, but that's the case that was being put at that time.
But even if that's right, that's not a suggestion of a twice signed.
Well, it is if he signs a draft. See, if you follow the story through, there's reference to the earlier draft being executed and witnessed by his wife. And then you follow it right through to 163, that comes earlier. Maybe I'm misreading it, but I thought what he's saying is that he signed it twice. Once in an unamended version and once in an amended version.
That doesn't seem to be picking up the version 5 and version 6 point, and does seem to be a rather different case. As I say, these are all part of the withdrawn paragraph.
Yeah, yes.
So, quite what exactly is being put, I agree.
It might bear a little bit more scrutiny. I mean, you may well be right that there's a certain amount of jumping about between versions 5 and 6.
Yes.
And that what Mr Hart is referring to in the earlier paragraphs is the finally executed version. It's not the way it struck me on first reading it through, but I think it will bear a little bit more concern. But you've got the point that if you actually examine the documents, he can't have signed them twice.
Yes.
I mean, that's the point that you're making.
Yes. I agree.
I mean, can I just correct that? We're checking it, but we didn't withdraw this evidence. So we keep being told it's withdrawn paragraphs, but it's not withdrawn as far as I'm aware.
Right.
The allegation is withdrawn.
The allegation, not
you
the
say, certainly in your skeleton and possibly in the letter which I asked for a reference for, that the topic will still require investigation.
because of the documents point. So this evidence is not withdrawn.
No.
The answer to your question about the letter is we do not have it in the bundles, but if your lordship would like it, we can procure
I
it.
must have imagined I saw it then. Perhaps I just saw a quote from it.
It's certainly been quoted from. That is certainly true.
Well, I hesitate to ask for more paper, but I think it might be useful to see it.
And if I could just trespass upon your patience on that point, if we look at the core bundle, tab 11, page 312. Up towards the top of the page, just above the number 10 paragraph, evidence in support of the allegations above is set out in ARH1 paragraphs 142 to 164, all of which is deleted.
Well, if you delete the allegation, you don't need to say where the evidence in support of it is. It doesn't mean that the evidence isn't evidence in the case. I mean, the point you've been making about the twice signed is a quite separate point from the point that you embarked on when opening this topic, which was you've withdrawn an allegation, so it's unfair to ask any questions about it. Are you going to come back to that point? Or
I've been seeking to demonstrate quite why it is.
Well, yes, exactly. You've said that it's dangerous and so on. So
Yes.
But as a matter of law, is it your submission that once the count of contempt has been dropped, which it plainly was, it is therefore improper to ask any questions about this topic?
One of the things that is made very clear on the authorities in contempt is that a defendant charged with contempt is entitled to know exactly what the charges of contempt against him are.
I understand
What
that.
is the evidence adduced in support of them?
I understand that. But he's not been convicted of contempt in relation to this charge because the charge has been dropped. So the question is, if you drop a charge, or never bring it in the first place, but make it plain in your evidence that you are going to seek to invite the judge to explore a topic in evidence, is that an improper way of proceeding when it's not one of the counts of contempt which the defendant is facing?
The issue at heart is that it must be very clear to the defendant what is the case he has to meet and what is the case he doesn't have to meet. And in relation to that, if you withdraw an allegation and you delete the evidence, the reference to the evidence that is relied upon, the reason why this was done was so that in the very substantial affidavit, this is all pursuant to directions ordered by Mr. Justice Cockerell, so that it could be made clear to Mr. Vik, beyond peradventure, which paragraphs were and which paragraphs were not, as it were, in play, in support of which allegations. And therefore, at the very least, if one deletes an allegation and deletes reference to paragraph number, one is entitled to assume that that bit of the affidavit is no longer in play. Certainly the basis upon which we proceeded was that the bits of the affidavit that were in play were the bits that were identified on the grounds of contempt by cross-reference as being the evidence in support of the allegation. If there is some other allegation in support of which those paragraphs of heart were being relied upon, then that should have been identified, and they were not.
So I think it is your submission that this line of questioning was inappropriate in the circumstances.
Yes. I mean, it's a point I popped up at the time and objected to at the time, and we maintained our objection. And fundamentally, you come back to the fact that this decision is not something that was even argued for by Deutsche Bank in their submissions. And in our submission, rightly, because it's simply wrong.
Yes, but they are, as my lord says, two distinct points. One point is that the judge should not have gone there at all, or the bank should not have gone there at all. And the other is that the judge made a, you say, fundamental misunderstanding of the evidence, which vitiates her conclusion.
Yes, I mean, we do say that they are linked in the sense that the problem with focusing on an allegation which is not a live allegation of contempt.
Well, I know you say that the second illustrates the danger of the first,
yes,
but nevertheless they are distinct points.
Yeah, they are independently capable of being relied upon, yes. Yes.
Right.
Can I just ask you about that? Normally, cross-examination, I may be wrong about this, but my understanding is that common law, cross-examination of a witness is not necessarily limited to the pleaded issues. You can cross-examine as to credit, and you can put to any witness that they have lied on an unrelated previous occasion. Now, if it merely goes to credit, doesn't go to the issues, you're stuck with the answer. You can't call evidence to impugn someone's credit, but you can cross-examine as to credit outside the pleaded issues, and you don't, in ordinary civil litigation, need to plead issues which merely go to credit. Do you say it's different for contempt, or do you say, or what do you say about that?
We say that in any event, but particularly on the circumstances of this case where a clear procedure had been laid down which was required to be followed, namely that the allegations of contempt had to be identified by reference to the evidence relied upon in support of them. If evidence was to be relied upon and arguments were to be relied upon in support, then it had to be identified, and it hadn't been. And therefore, one is entitled to assume that the evidence and the allegations in relation to that aspect are not relied upon in support of any allegation of contempt in any form, and therefore that's not a path that's going to be pursued.
When you are cross-examining on credit, you're not required to give notice of your cross-examination to the witness, are you?
In this, certainly for the purposes of these proceedings, it may be a safeguard that is commonly adopted in relation to contempt, the precise nature of the case and the evidence relied upon has to be clearly identified. But for reasons I've indicated, I don't have to go that far. Because in any event, there is a clear, and having gone there, the learned judge then adopted an argument that hadn't been addressed or advanced to her by either party, and then laid very great weight on it. So on any view, it wasn't a fair route, but that is borne out of the fact that it is a decision on an allegation which hadn't been formulated, and hadn't been identified by reference to the evidence that was to be relied upon in support of it, and therefore it was, as it were, a surprise. Indeed, nevertheless, the learned judge's finding is then insupportable in any event.
Thank you. It can't have been an enormous surprise, as it only emerges in oral argument in the Court of Appeal. And it's not in your skeleton or notice of appeal.
Well, it's a manifestation of the point that we do make in our skeleton argument, namely that we shouldn't have gone there. And it's an explanation of why we shouldn't have gone there.
Right, having gone there, where do we go next?
Well, just to close that off, we do say that the learned judge attached a lot of significance to that finding. It emerges from extensive paragraphs of her judgment. Ones we've already looked at, 86 and 95. And then you see it then begins to interweave into everything else, because when you then look at paragraphs 96 to 98 of the judgment, when addressing interests in Devon, the issues relating to Devon Park and the issues relating to Beatrice, at paragraph 97, whether something is a plausible explanation in the context of the specific allegation, i.e. reasonable or likely, although question mark where the burden of proof is being applied here, depends on the circumstances, but also on the court's assessment of the overall reliability and credibility of his evidence. In reaching a conclusion as to whether the evidence excludes all realistic possibilities consistent with the defendant's innocence, the court is entitled to and does take into account the court's assessment of the overall reliability and credibility of Mr Vik's evidence. So again, the foundation is the flawed general assessment, which then taints the specific investigation. Again, at paragraph 104, the paragraph that we were looking at previously, considerable caution because of her findings on the general issues which we've looked at, and in our respectful submission established as unsound. Paragraphs 105 to 106, the judge is alive to the danger of the reversal of the burden of proof. It says, no, that's not how it works. You refer to documents, evidence being reliably corroborated by the documents. In this case, it's alleged by the bank that some documents, notably the sale agreement, are not bona fide documents, and thus the extent to which Mr Vik's evidence is corroborated by the documents also depends on the court's assessment of whether such documents are themselves reliable. We've already seen that one of the reasons why the learned judge attached so much significance to the twice signing issue was because she said that she needed to look at a topic like that to get an assessment of general credibility in order to come on to her assessment where there were other documents, the reliability of which was being questioned. So there's a cross-contamination there as well. And then it carries over to paragraph 170. In the specific, we're now into the section dealing specifically with Beatrice and the trust, it starts off at 170. However, the credibility of Mr Vik's evidence that he was advised to distance himself and did so has to be weighed against the court's general assessment of his credibility. Again, the earlier section we've been looking at comes back in. And at paragraphs 190 to 192, again, paragraph 190, the credibility of this evidence has to be assessed not only in light of the court's general assessment of Mr Vik's credibility. Paragraph 192, the purported explanation appears to lack any real justification. It has to be viewed in light of the court's assessment of Mr Vik's general credibility. Paragraph 265, dealing now specifically with Devon Park. When she is looking at the terms of the 2012 sale agreement, which I'll come back to, again, she says, given the unenforceable trust provisions, that's the Norwegian law point, which I'll come back to, I infer that external lawyers were probably not used. The credibility of Mr Vik's evidence that he did not know has to be assessed in the light of, one, the court's assessment of his credibility generally, and then at 307, in the context of universal, at page 252 in the bundle, in assessing the credibility of Mr Vik's answers in relation to the instructions in 2014, the judge says this evidence, in my view, was simply not credible when considered against item number 1, the court's overall assessment of Mr Vik's credibility. 326. Under the conclusion for the Devon Park interest, that submission ignores a number of matters. That was a submission made on behalf of Mr Vik that you could not reject as incredible, see at the bottom of page 257 at paragraph 325, the possibility that the information signed in documents signed as they were by Mr Vik was incorrect, but that the evidence he's giving to the court in relation to the 2012 sale agreement is correct. And this is the short point, that having established, as it clearly was the case, that Mr Vik did sign documents without careful reading of them, he signed what was put in front of him, the question arises, do you in those circumstances believe that Mr Vik is now telling a lie to the court and in the face of the court, or that his method of doing business, namely signing of documents without reading them and ensuring that they're correct and relying upon others, means that he will have signed things that are not 100% accurate or 100% enforceable under Norwegian law? And again, the court says, no, you've got to assess that submission against the assessment of the credibility of Mr Vik's evidence generally. So again, he's defeated before he's even stood up. And at 415, in relation to the documents, again, page 278 of the bundle, as part of the overall context of considering the allegations against Mr Vik and the inferences to be drawn from the evidence, I do not accept the submission that Mr Vik produced hard copy documents effectively. There's no explanation, as held above, for the manuscript amendments to the Carlisle deeds, which must have been made deliberately, and in my view this was a deliberate attempt by Mr Vik to mislead by his disclosure and by his evidence to this court that he did not know anything about the different versions. And again, that goes back to the point, the basis on the evidence, which is in our respectful submission fundamentally flawed. And then at 417, in my view, whilst it is true that no one had sought to counterfeit the signature of the general partner on version 5, this submission ignores the obvious inference that Mr Vik nevertheless put forward documents which have been deliberately altered in a way which would support his case. No mitigation or explanation of the actions of Mr Vik can be found in the fact that no one had gone so far as to fabricate the signature of the general partner. And that's the point, simply, that if this is all supposed to be some sort of misleading fabrication, the question arises, well, he didn't even try to suggest that this was an executed document. He didn't even produce one which had all the relevant parties signing it. So that it wasn't the final completed executed document was apparent on its face.
I'm a bit puzzled by what the judge says about documents which had been deliberately altered. She seems to be treating version 5 as an altered version of version 6. And that may explain her reference to manuscript amendments, because they're not amendments if they're simply version 5. And indeed, I think that may have been a theory which Mr. Hart put forward.
My understanding, and it's not altogether clear, but my understanding is that the suggestion is that in 2015, the version 5 was doctored by the addition of dates which were not present in 2008-9.
Yes, I see. Yes.
And fundamentally, this is the problem with trying to found every single one of these subsequent allegations as the starting point. Well, look what I found in relation to this allegation, which is not an allegation of contempt. It's one that was dropped, the relevant paragraph numbers crossed out, and I have formed my own view on a point which wasn't even addressed to me, namely the twice signing. It then pervades all of the specific and individual findings thereafter.
You say your understanding is that the dates were written in 2015.
That's my understanding of the judge's theory.
Right. That wasn't Mr. Hart's. Wasn't the case being put forward by Mr. Hart?
No, not as I. My understanding of the judge's theory is that in 2015, when this document was disclosed for the purposes of the Part 71 transaction, Mr. Vik had taken...
It was deliberately backdated
Yes.
to 2008.
Yes.
Yes. That doesn't, as I say, seem to be what Mr. Hart is suggesting. Mr. Hart does suggest that there had been a Debevoise draft, which had been amended in manuscript to provide what we have as version 5. But as I read it, his suggestion is that was done at the time, in 2008.
But we are not clear what the allegation is.
Yeah.
For my first point, I shouldn't have to be.
Yes, no, I
It
understand.
shouldn't be there in the first place.
My lord, I am objecting because a lot's being made of what Mr. Matthews doesn't know. But if any of this had been in his skeleton or grounds of appeal, then we would have been able to answer it. And we're all proceeding on a basis where he's speculating as to things that were never put below. The chronology of this is that Mr. Vik didn't produce any documents in 2013 when these transfers first came to light. Travis Smith, his solicitors, said there were no documents. In 2015, he produced the 2008 version 5 deed and said, haha, they were done in 2008, not 2009. And that was the evidence that was produced to rebut the idea that there had been asset stripping. He was then questioned about it at the Part 71 hearing. And then what then happened was we got a Norwich Farm Court order, and the order produced version 6 plus other documents, which demonstrated that there were differences in what Mr. Vik had produced when his solicitors had said there were no documents. Suddenly, we then have another set of documents from the partnerships that show that the dates, your lordship asked what had been amended, and it was the manuscript dates and the as of effective date. And we show all the differences which are set out in Mr. Hart's evidence that was served in advance of the contempt hearing, and they're all listed out, all the many in the whole passage. And although Mr. Matthews keeps saying that there was no allegation of contempt, he kept raising this below, and that's just not right. There was no allegation of contempt that Mr. Vik was lying about the partnerships, because there was a separate but overlapping allegation that he had failed to produce the documents.
Yes, we understand that.
And so there is an allegation of contempt. And so when all the questions are being posed as to whether it's appropriate to have cross-examination on an allegation, where there's no allegation of contempt, I just wanted to make that clear. But Mr Hart's evidence was all set out, and I think my Lord Justice Mayle said one doesn't have to explain one's cross-examination, but actually all of this material was there before Mr Vik went in the box, and he didn't express any surprise about being asked about them. And then it was not till, I think, over 24 hours that re-examination took place, and there was no re-examination and no case in the written or oral closing or in the skeleton of this nature. So I just think it's important that this is highlighted before the question goes too far, because Mr Matthews is making out a case that he's been taken by surprise or there's been an unfairness, which is just not sustainable.
Well, at the moment, I think we're on a fairly narrow point. I think we understand the points that you've made and what you say about the documentary contempt being still in play. But the fairly narrow point has been made that the judge got something wrong.
That's right, and that's new, and I'll address it.
About two signatures, and that was an important part of her reasoning on this point, and that her reasoning on this point infects her reasoning on other points, because it goes to her view of overall credibility, and as we see throughout the judgment, whenever she comes to a point, her view of overall credibility is a factor which leads her to decide in your favour rather than Mr Vik's.
Yeah. Well, my Lord, that point's new, and we'll address it. Mr Matthews seemed to be going much wider, and I think my Lady Justice Andrews was questioning his case that was put today that was all new about the execution of the documents, and that case, if it's being pursued, needs to be put in writing, as does this point, and of course we'll address it. But I'm just simply saying that it's a bit rum after 3 applications to produce new evidence, skeletons, an 11-day hearing, to have quite a lot of time today taken up with an entirely new case that we're listening evolve, and it seems to be almost on not a premise that I think is a fair premise.
Yes. All right, thank you.
If I may just complete one more reference to the significance of these findings, and that's in the sentencing judgment, where again it carries over at paragraph 26. At page 294 of the core bundle, where Her Ladyship said, in relation to the hard copy documents that Mr Vik did produce, it appears in relation to the Carlisle deeds that documents he had produced had been deliberately altered, that's the manuscript amendment point, and as found by the court, this was a deliberate attempt by Mr Vik to mislead by his disclosure. So there's reliance placed again in the context of the sentencing, as well as the findings of contempt. And in that context, I just touch upon the application to tender additional evidence, which you have in additional bundle 2, I hope, which should be a slim bundle with both parties' submissions at tabs 1 and 2, and then the application notice at tab 3. And the bit that we're concerned about in this context is the deposition evidence of Mr Johansson, which he gave in 2017. And the short point in relation to this, I don't propose to develop it in any great detail. I'll simply refer you to, in our submissions, it's developed tab 1, paragraphs 4 to 7, and paragraphs 15 to 23. And the short point is, this is evidence that Mr Johansson had given in deposition in 2017, where he said that the writing on the documents was his manuscript documents, and that it was made in 2009. And therefore, again, the idea that it was Mr Vik who amended the documents in some way is addressed and is not correct, and the idea that it was done deliberately by Mr Vik in 2015 in order to produce a deliberately misleading document for the Part 71 is also in effect dealt with. There is no evidence yes, there's no suggestion that Mr Vik had any involvement in the version 6 process, or indeed in the whole process, other than to sign, as he did and as we have seen, version 5, not version 6. And given the central importance of this issue to the way in which the learned judge addressed the evidence, it is clearly, we say, expedient and necessary and expedient in the interests of justice that all evidence which can be deployed should be deployed in relation to the issues before the court, for the reasons that we develop in the further evidence application. We acknowledge, of course, that in principle that was there in 2017 and was therefore capable in theory of being deployed in the evidence before Mrs. Justice Moulder, but the reality is that there are proceedings in multiple jurisdictions and parties don't always immediately light upon the relevant bits of evidence that they need or should advance, and especially in circumstances where the nature of the allegations was not one of the contempts and in which it appeared that the relevant supporting evidence of Mr. Hart's affidavit was no longer being relied upon because the allegation and the reference to it had been deleted. In those circumstances, it is not, we say, a matter of complaint that the Mr. Vik did not light upon it at an earlier stage. It's now before the court, and the court can and should take notice of the contents of it. But I don't know whether it's your lordship wants me to develop that at all further. I wasn't proposing to, but I'm in your lordship's hands in relation to that. It's a short passage in tab 6. It focuses, the bit that's exhibited there focuses entirely upon the circumstances in which these documents were signed and provides Mr. Johansson's evidence in relation to that. Right. Lord Sarek I can take briefly. The point in relation to Sarek is at an even further remove because it relates not directly to the abandoned allegation about Wrighton, but whether the transferee of Wrighton was Mr. Vik's company or Mr. Johansson's company. We've dealt with that in detail in our skeleton argument at paragraphs 55 to 67. The point is, again, that even more so, really, in relation to Sarek than in relation to Carlisle or Wrighton, which were the sort of, as it were, the primary allegations which had not been pursued in relation to oral evidence. In relation to Sarek, as I say, it's a subsidiary one. The ownership of Sarek was not a live allegation of contempt, and it was wrong to engage with the topic, let alone to attach fundamental significance to it through the door of credibility. And we have, again, set out the position in relation to that as a matter of principle in that section of the skeleton. And again, the same principles in relation to the cross-contamination apply, and I don't need to go further over there. And ultimately and finally, the short point is that Mr. Vik's oral evidence, as we see from paragraph 4, Mr Vik's oral evidence was found to be relevant and highly relevant to his general credibility in relation to the live allegations of contempt, and therefore the more inappropriate that they were addressed in this way. I move then, if I may, to the third basis upon which we say that the judge fundamentally went wrong in relation to her assessment of credibility, and that is in relation to the evaluation of Mr Vik's oral evidence. And I appreciate that singly many of these points may be said to be points that a judge is entitled to take into account and decide and address in assessing credibility or honesty, but we do set out in detail in our skeleton argument at paragraph 68 to 70 a whole series of principles which we say should have been applied by the court in enabling, ensuring that a witness gives evidence in a good, as it were, and fair environment, and how a witness typically would behave in those circumstances, and essentially the approach taken by the judge is that if Mr Vik said he couldn't remember something, then it was said, well, Mr Vik's a very capable man, and he must have been able to remember everything, and therefore the fact that he says he can't remember anything is an indication of the fact that he's not telling the truth or he's not cooperating. And if conversely he remembers everything, it's said that, well, he's unfazed by the whole thing, and therefore anything he says which is somehow inconsistent with the document must demonstrate that where he says he doesn't really know about a document, he's got it all wrong and he's not telling the truth. A witness faced with that assessment of his credibility can never win. Ultimately, whatever he says, you're damned if you do and you're damned if you don't, is, I suppose, the neatest way of encapsulating the argument. And the point is that when we then look at it, having addressed the general principles of paragraph 68 to 70, at paragraph 71 to 73, we give an example of examples of how this operated in relation to the trust deed. Now, the trust deed, the setting up of the trust, essentially what was the approach that the judge took in relation to the trust is exactly as I say. If Mr Vik can't remember a provision of a trust deed, then he must be not telling the truth. And if Mr Vik can remember an element of a trust deed, then it demonstrates that he's all over the evidence and he's on top of the evidence, and therefore he's in a perfectly strong position to answer every question. And wherever he then falters, it demonstrates that he actually could and should have answered the question easily. So that we say is an unfair linkage.
That's a true dichotomy, because could it not be said that a witness who is generally on top of the evidence and appears to have a great deal of mastery of it, that there may be then some suspicion to be attached to the fact that he suddenly fails to have that degree of grasp of the evidence when it comes to something that's critical?
I accept at the outset that individually these matters can arise in the judge's assessment of the witness's credibility. It is, we all know perfectly well that there's the witness who can answer everything extremely well, and then suddenly when the most difficult question comes up, there's a real problem of some kind or another. Yeah. And of course, I acknowledge that that is an entirely legitimate process of analysis by the judge of the credibility. What we address in our skeleton at paragraphs 71 to 73 in relation to the trust deed is really the sort of more fundamental questions about how the fairness of the assessment in relation to that seems to have been lost sight of. If you take 71 paragraph 1 in our skeleton, which concerns the judgment, paragraph 66 to 67. And in that, Mrs. Justice Moulder says at 66, at the cross-examination hearing, and of course that's back in 2015, when asked about the trust deed, Mr. Vik accepted that he was generally familiar with it. Actually, the question answer says, are you familiar with the document? I haven't looked at it for years, but generally I was familiar with it, yes. Then further at the cross-examination hearing, Mr. Vik was taken to provisions of the trust deed, such as the provision that the trust was revocable and that his wife could revest the trust property. This trust is entirely revocable, isn't it, Mr. Vik? Yes. And your wife can revest property to you, just as your spouse, can't she? I don't know. That nobody has identified why it matters that he didn't know the answer to that question, but he did know the answer to the first question. Now, if something turned on it, one could quite understand a judge saying this was an absolutely vital element of the piece, and yet suddenly Mr. Vik says he doesn't know in his answer. But nothing does turn on it. So why does that demonstrate a sort of chopping and changing position on the part of a witness, rather than the perfectly normal position of a witness? Is that they might have been familiar with the documents, they know some bits, but they can't be guaranteed to know all the bits. And as Justice Andrews pointed out, you do indeed get circumstances where they remember an answer perfectly easily until they get to the difficult question. But it's not suggested as to how this is a difficult question. But anyway, then at paragraph 68, it is said, well, we can contrast this with the evidence given to this court. Well, first of all, of course, the evidence given to the court was not in 2015, but in 2022, and 7 years later. So how one builds that, it's not clear. But also, if one then looks at it, Article 2, we see the trust is revocable in whole or in part at any time on your instructions, correct? Answer, yes, I read that. And it's underlined that he says, I read that, because somehow the fact that 7 years previously he'd said, I'm generally familiar, and was able to answer yes, suddenly is to be held against him when he says 7 years later in 2022, in answer to the same question, yes, I read that. This is, with respect, a very harsh approach to be taken to an assessment of credibility. And you agree that the trust is revocable at any time, in whole or in part, at any time on your instruction. That's what it says, yes. And again, underlined, as though there's some criticism that could legitimately be placed against that sort of evidence. If we go over to the page, please, to the next provision, this is grantor's spouse shall have the power exercisable at any time to revest absolutely in the grantor. And that's, one has to bear in mind, this is being done over electronic screens. We didn't do paper versions, or at least the witness didn't, and I didn't for the other one. And the judge didn't. And so it is a legitimate question to be asked when something is read to you. Do you want me to look at it? And yet it's underlined as being indicative. And the question then follows, yes, Mr. Vik, I'm surprised you're not more familiar, but it's going to take a little while if we're going to have to read the document, as if you have never seen it before. Well, is it not legitimate for a witness who's being asked on pain of imprisonment to give fair and accurate answers to something, that he be entitled to read the document if something is said to turn on it? I mean, this sort of approach, and the conclusion then is drawn from it at 69. Mr. Vik's manner of giving evidence in relation to this court in relation to the trust deed and his purported ignorance of key provisions was not, in my view, credible in light of both his previous evidence at the cross-examination hearing, but more significantly the fact these key provisions were the basis upon which he transferred. And of course, bearing in mind the transfer was in 2008, so that's 13 years previously, 14 years previously, $700 million of his assets to his family through the trust. And as I say, I appreciate the fact that judges have the job of assessing the credibility. The Court of Appeal is not likely going to interfere with the approach. But when one looks at the way in which the matter is approached,
Is that an unrealistic point for a judge to make? $700 million is a very large amount of money, even by Mr Vik's standards. His evidence to the Connecticut court was that he was doing this to set up his family wealth for his children. One would expect a settler, even after 13 years, who had done such a thing, to know whether that was irrevocable or revocable. Wouldn't you? That's the point the judge is making.
But
it's not as if this is something that somebody else has done which he has a tangential knowledge of. This is something that he has engineered and done. And there is a well-recognised and major difference between settling something irrevocably and settling it revocably. In the latter case, it really remains your property under your control, but in the former case, it doesn't. And that makes a difference to $700 million worth of wealth.
I follow that analysis. I also accept that a lot of it turns on the judge's assessment of the witness, and his position was that he had been advised to distance himself from the trust in consequence, and I'll come on to deal with aspects in relation to that. And so there were all these other elements and factors in play. And as I say, I acknowledge the fact that the court is entitled and indeed bound to take a view, but what I was focusing on was a slightly different point. There is said to be some inconsistency between this approach, that evidence he'd given in 2015, some relevant inconsistency in the evidence he'd given in 2015, the evidence he'd given in 2022. It is, with respect, very difficult to see what relevant inconsistency there was. And if you go back to 68, he's being referred to a document, Article 2. We see that the trust is revocable. Yes, I read that. He's not challenging the principle. Yes, I mean, ultimately what we say in relation to this is that an acknowledgement that you are generally familiar with the terms of the trust doesn't necessarily become inconsistent with, at the time or 7 years later, being unable to remember a particular detail as to whether a spouse can or cannot revest or something like that. There are different points. And so the short point we make is there isn't a real inconsistency, or there isn't any inconsistency between the evidence that he gave in 2015 and the evidence he gave in 2022. And even if there were, it's not altogether surprising. Ultimately, does that mean that a witness is not entitled to read the document that is put in front of him electronically when he's being asked questions about it, the answers to which, I mean, this is not a new process in one sense for Mr Vik. That may count against him in one sense. It certainly counts in his, should or count in his favour in one sense, that he's been cross-examined. He's had the unpleasant experience, both at trial and being disbelieved, and on the Part 71, which was then followed by contempt allegations, and then through this process. It is hardly something that a witness is going to be utterly relaxed about. It's something a witness is entitled to be cautious and careful about, and shouldn't be criticised, and it shouldn't be held against him if he adopts that approach.
When you say he was disbelieved on the Part 71, the Part 71 doesn't lead to a judgment.
Sorry, if I said disbelieved on Part 71, I didn't mean to say that. I said he'd been disbelieved on the evidence he'd given at trial. He'd then given the Part 71 evidence and been subject to a committal application.
Yes.
It's certainly been disbelieved by Deutsche Bank.
Yes.
But yes, I'm not suggesting that the judge had any involvement in that analysis. And so we do say that the approach that the judge adopted in relation to his evidence was at a level of analysis or expert behaviour to be expected of a witness, which is simply not justified or justifiable. again, at paragraph 72 of the skeleton argument, we identify other aspects relating to this, where the judge says there's something odd or strange about the evidence that the witness was giving by reference to the judgment at paragraphs 72 and 73, which is a classic sort of situation where in quick succession two different page numbers are given to a witness and he seeks clarification of which one he's being asked to look at. It's from the extract at paragraph 72. And it's not unreasonable for a witness to be entitled to clarify and be careful and be sure that what he's being asked to look at and asked in connection with is what he's looking at on the screen. So, whereas the judge held at paragraph 73 that that was an example of Mr Vik seeking to avoid answering direct questions and attempt to obfuscate. Well, we say that's, to say the least, harsh, but it is part of a picture which we have put together in relation to the paragraphs 68, or 71 to 73 of the skeleton argument, explaining these many instances where if you look at the basis of criticism which the judge advances in relation to the evidence given, it is with respect difficult to see how they can properly be advanced as genuine, no, not genuine, as valid criticisms of the way in which the witness gave evidence. And the conclusion, we say, is the judge drew unjustified inferences concerning the honesty or accuracy of Mr Vik's evidence, which again were the sort of third limb of the basis upon which she concluded that his overall honesty was not made out, and therefore carrying on from that, in each of the allegations, as I've demonstrated, having concluded the general credibility issue, then came to the conclusion that the Mr Vik not only had no general credibility, but that because of that, on each of the specific ones, allegations of contempt, his evidence in relation to the matter should be rejected. In essence, a witness in the position of Mr Vik is left with that sort of analysis on the basis that he can do no right. And the effect of that is to give the impression of a reversal of the burden of proof, in the sense that everything that Mr Vik then says is disbelieved in principle because Mr Vik has said it. And so for those reasons, we say the approach to credibility of the judge was, again, fundamentally flawed. And it's against that background that the judge came on to the specific allegations against Mr Vik, as do we. Now, I haven't taken a lot of time, or any time so far, with the court in relation to the applicable legal principles on a review by the Court of Appeal. And I have hesitated to embark on that path, not for the reasons attributed to us by Deutsche Bank, that our presentation of our appeal trespasses in a way which is unacceptable in relation to the court's role, but simply because I anticipate that the area is well known to this court in any event. It has been the subject of 3 recent Court of Appeal decisions at least, Walter, Lilly and Chin and Klin, which is in your bundles at volume A, tab 45. Sorry, I must stop calling them volume A. It's A is for authorities. Of the authorities bundle, volume 45. Elliott, tab 46. And Volpe, tab 51. Obviously, my Lord Justice Males will be very familiar with Volpe. The lead judgment in Volpe was given by Lord Justice Lewison. who agreed in Walter Lilly with the lead judgment given by Lord Justice Carr, and the lead judgment of Lord Justice Warby he also agreed with in Elliot, without any indication of any intention to depart from, or that they gave rise to different tests. And we're not suggesting to the court that they give rise to different tests, and we anticipate the court knows perfectly well the exercise that it is supposed to embark upon on a review of a decision of a lower court, essentially on matters of fact. And so I don't propose to develop that at any length. The law remains as encapsulated, at least in those three judgments. We do say that Volpe is relatively narrowly expressed, probably because of the issues that arose in that case. Whereas the exposition in Walter and Lilly at paragraphs 83 to 87, it is a more extensive analysis of the role that the Court of Appeal performs in relation to this, and therefore the rationally insupportable analysis is not the only test, although of course we say with respect that we satisfy it on this case. Obviously we recognise also that the Court of Appeal will give great weight to the evaluation of the oral evidence of the witness before the trial judge, but conversely, what we would also reiterate is that the Court of Appeal in this case is as able to evaluate the evidence given in the Part 71 cross-examination, which you have in transcript and Mrs. Justice Moulder had in transcript, as was Mrs. Justice Moulder, since she was not present for that cross-examination either. There aren't huge differences between the parties. The Deutsche Bank skeleton argument at paragraph 41 puts it in terms of the court will only interfere if it's satisfied that the decision below is A, wrong, or B, unjust because of a serious procedural or other irregularity in the proceedings below. It's probably on the gloss that applies thereafter that there's a difference between us, and we say we satisfy both those tests for the reasons we set out so far in writing and orally, and I will come on to develop further. The Court of Appeal should indeed be satisfied that the decision is wrong. Furthermore, the reliance by Mrs. Justice Moulder on questioning and conclusions on points that were not fully in evidence before her, and the fundamental conclusions that she reached in relation to those issues was not only, we say, wrong for the reasons we've indicated, but a serious procedural or other irregularity. And so we would satisfy both of those. Again, the test encapsulated as no reasonable judge is putting it too high, but you do need an identifiable error as to law, fact, or reasoning. An identifiable error, a fundamental misunderstanding of issues or of evidence, and this is Walter and Lilly, and it's all down, I won't take too much longer on it. Failing to take evidence or material factors into account, taking irrelevant evidence of material factors into account, errors of law, gaps in logic, lack of consistency, or arriving at conclusions which the evidence could not on any view support. Again, we don't accept that perverse is the correct analysis, rather the tests that have been set out in the three Court of Appeal cases we identify with the caveat that Volpe might be slightly narrowly expressed because of the circumstances in which it arises, is the true approach. And the threshold is that the cogency of the judge's conclusion will be undermined if the Court of Appeal is satisfied that the relevant finding of contempt is unsafe. That's Walter Lilly at paragraph 86, adopting Abliazov number 8 at paragraph 49. So once it is established that the judge made a substantial error in her approach, for example, to credibility, the Court of Appeal is faced with the fact that the judge used her findings on credibility to find against Mr Vik at every turn thereafter, and in those circumstances the court is entitled, and indeed we say bound, to review the matters relied upon by the judge to form a view as to whether the specific grounds of contempt were properly established. And I'm now going to turn to the particular examples, the particular grounds of contempt. And I don't know if that's another convenient moment. I'm told that for the purposes of the external transcribers who are indeed transcribing by reference, I believe, to the YouTube broadcasting of this proceedings, a brief pause is required if there is to be a running current transcript.
Yes. All right, we'll take 5 minutes.
I'm very grateful. Yeah, just yeah.
Quickly and nicely.
So 9 a.m. tomorrow.
Yeah.
Is that all right?
Yeah.
Hopefully between what you said and that and what I said.
Yeah.
Do you want my notes?
That'll be down on the transcript.
Yeah. Yeah. There's a sort of distillation. Oh.
Yeah, because there's nothing else that isn't either in the transcript or in the
No, I went through it. Yeah. But I mean, if you can drive it from what I wrote, because it's deliberate distillation of a note, that would be good.
Court's rise.
Well, turning first to Beatrice and the trust, we deal with this from paragraph 74 of our skeleton argument, and the issue is set out at paragraph 74, the question of whether Mr Vik is guilty of giving deliberately false evidence about his knowledge and or ability to provide information about the various entities, Beatrice and the trust, at the 4 points identified in paragraph 74. And we say that in analysis, the judge made 2 errors which independently and cumulatively undermine the judge's conclusion on this issue. And the first is, what is the meaning to be ascribed to the relevant answer to the relevant question that was asked in cross-examination at the Part 71 cross-examination, where we say the judge misinterpreted the transcript of the evidence at that hearing, because in essence she concluded that he was being asked in broad terms what the assets were in those questions, and he had understood, he says, that he was being asked in those particular questions, having addressed a whole series of broad questions, exactly what assets the trust had at the various different times, to which his answer was that he did not know, brackets, exactly what knowledge, exactly what assets the trust and Beatrice had at the dates identified. And secondly, the second independent, but also cumulative challenge to the decision on this finding of contempt is as to the judge's inferences that she drew as to Mr Vik's actual knowledge of the assets of Beatrice and the trust. And we say they were founded on material errors of law, reasoning, and factual misunderstanding. And so we turn to those. First of all, what answer did he give? What is the true construction of what answer he gave? And we turn to that at paragraph 77 of the skeleton. And as I mentioned before, of course, in that respect, reviewing the transcript of a hearing before Mr Justice Cook, the Court of Appeal is not dealing with a situation where the judge below has taken a view of the credibility or otherwise or demeanour of the witness. It's a question of construction of the words in the question and the answer, and this court is as well placed as any other judge who is not participating to form a view as to the construction of that. So what did Mr Vik understand the question and answers to be? Was that an objectively possible construction of the transcript? If not, is the court nevertheless sure that Mr Vik did not so understand the questioning in the way he says he did? The relevant questions are set out in paragraphs 82 and 83 of our skeleton argument, but I just touch on at paragraph 80. We have said, in other words, if the court considers that Mr Vik could conceivably have understood the question to have a different meaning, that is probably putting it a bit high. And we recognise that there's a real possibility that Mr Vik could have understood the question to have a different meaning would be the better wording. And we take that from Eroshenko in tab 40 of the authorities at paragraph 40. And so that is the test. Is there a real possibility that Mr Vik could have understood the question to have a different meaning from that which the bank has to be alleging in order to establish that there was a deliberate falsehood?
Just so I understand what the evidence was, have I correctly understood that at the Part 71 hearing itself, Mr Vik didn't say anything about how he was understanding the question? He simply answered it. No, I don't know, or whatever he said. But at the committal hearing, his evidence was that he had understood the question as being limited in the way that you say.
Correct, my lord. And limited in the sense that, having addressed questions about what assets did the trust have, answer, transferred into it were the shares of Beatrice. These sort of things were known and common knowledge.
Yes.
So the question is, what further knowledge or information could the line of questioning of which complaint, or the line of answers to questions of which complaint is made, have been driving at,
Yes.
given the general information which was provided? And so, for example, again, it was, there was plenty of evidence to say that the assets of Beatrice, as distinct from the trust, the assets of Beatrice were cash or cash equivalent, which is what had been transferred into it, and there's evidence to say that the decision was taken to maintain the status quo, that there was no intention to suddenly indulge in some different type of investment. And all of that...
I think it's, sorry to interrupt, I think it's common ground, because I think Ms Delaney accepts this in her skeleton, that at the committal hearing, Mr Vik's evidence was that at the Part 71 hearing, he had understood the questions in a limited way. So I don't think there'd be any dispute about that, but I think I'd find it quite helpful to be shown his evidence to that effect at the committal hearing, if you can give us a reference at some point.
We'll come to that, my lord. Yes, thank you. And the we pick up on it at paragraph 83 of our skeleton argument, and this may be the route we refer at paragraph footnote 13 to the closing submissions, paragraph 32, which is in supplementary bundle, core supplementary, tab 18 at page 126.
Are these the closing submissions for the trial before Mrs Justice Moulder, or the closing submissions for the Part 71 hearing?
Trial before Mrs Justice Moulder.
Right, okay, thanks.
And it's paragraph 32. There's no material dispute as the evidence Mr Vik gave. Mr Vik accepts the substance of his response was that at the time he was being questioned, he did not know and could not say exactly what assets or funds Beatrice or the trust had, either at the date of the cross-examination hearing or in August 2015, which was 4 months earlier when he'd ceased to be protector. And so and at paragraph 47 of the closing, sorry, no, past that. I'll come back to that. So, and I will come back to the Lordship with the transcript passages from the committal hearing. And so,
I mean, I've seen the passages where he answers the questions, which are at page 56. It's where he says, I thought that I was being asked something more limited, is what I'd like to see.
Yes.
Yeah, okay.
And the point in context is simply that what is the purpose of the Part 71? The purpose of the Part 71 is to assist Deutsche Bank in enforcing the judgment as the judgment creditor. In order to do that, being able to give further information along the lines of it was invested in cash and cash-like or cash-equivalent investments or securities, obviously is not going to be of great assistance to man nor beast. But that information was out there anyway, because that was the case that had been, the evidence that had been put forward. So when Mr Vik is being asked further questions specifically, can you tell the court what assets Beatrice had in August 2015? He could have repeated, yeah, as I recall, it had cash or cash equivalent. But that wasn't a further point of information that could possibly have been of interest. That was already what was already known, because that is what had been transferred in 2008, and the evidence was that there had been no change of policy in relation to investment. So that doesn't take you anywhere. So what is he being asked when he's being asked, can you tell the court what assets Beatrice had in August 2015 when he retired as the protector of the trust? Now, Mr Vik says he understood that to mean not just what class of assets, what type of assets, but what assets. Were they invested in this corporate bond or that country's gilts or what? And that's what he says. No, he doesn't know the answer to that. So that's the first stage of the equation. Was that, first of all, was that how Mr Vik understood the question? And was that a legitimate understanding of the question? And in our submission on both of those points, A, yes, it was legitimate, and B, it's the only really sensible explanation, because otherwise, as I say, to reiterate in broad terms what he'd already told by way of evidence and what was already known to Deutsche Bank was obviously not of assistance. So if this is to be something on top of that, it must be something more detailed. So he's being asked the detail. Did he have the detail? Answer,
well, the question
no.
is how much detail. I mean, I get your point about they already know that there's cash, but someone might say when answering that question, well, I know that the assets were in cash or in equivalent. I can't give you the precise names of the bonds, but as far as I can recall, it was held in X bank in an account which had an investment element, and it was in, I seem to remember that there were some corporate bonds, but I can't tell you precisely what the corporate bonds were or who it was with. Now, you might get that.
Yes.
So there are different degrees of particularity that an honest witness might come up with. What you wouldn't expect is if somebody knew that it was cash and cash assets but had some sort of handle on this investment, a blanket, I don't know any more than that it's in cash.
Or cash and cash equivalent.
Or cash equivalent.
Yeah.
Because you'd expect them at least to be able to say, well, it was cash and it was held with X bank. Or
Well, there was quite a lot of evidence that HSBC, because HSBC was the bank through which the transactions by which money was being transferred from Beatrice to SHI and back from SHI to Beatrice. So that was also already known. And indeed, Mrs Vik had given evidence that as trustee, she left the management of the funds to HSBC.
And when did, I don't have in mind the chronology. When did Mrs Vik give evidence?
The deposition, sorry, forgive me, I should know the answer to that.
Well, come back to it.
Well, I can deal with it now, thanks to Mr. Hamilton. That is July 2015.
So shortly before Part 71.
Yes.
She was deposed in the United States in connection with what litigation?
It was all part of the efforts to enforce the judgment. Specifically, which element of it, I can't tell you, Lordship, but we have the deposition at tab 34 of the supplementary bundles, so tab 3 of that. And the questions she's being asked are as to the operations of Beatrice and the business of Beatrice.
That looks like the Connecticut proceedings. If you look at the
I wondered if it might be.
docket number.
Yeah. Yeah, I'll take that. Yes. Yes.
And what was the date of the Part 71?
December 2015. The actual cross-examination was December 2015.
Thank you.
But I'll come back to that in a little more detail. And so I entirely take your ladyship's point that one might provide that sort of information, but that sort of information in the sense that the funds were being handled through HSBC was something that was already known to Deutsche Bank. They had information about the exchange of payments going backwards and forwards from SHI to Beatrice and back, because what had happened in the early days was that the SHI had been doing well in the early days after the transfer and of the assets into Beatrice, and therefore there was a flow of assets from SHI to Beatrice. Subsequently, the flow reversed, as it were. There was a total of 80 million of transfers, $80 million of transfers, I think it was, and a total net outflow of 25 million, or that order, $25 million, as between those two. So, and that was something that, again, Deutsche Bank knew about. So when one asks oneself sort of what further, if, of course, Mr. And this is the second part of the analysis, of course, Mr. Vik had exact knowledge, if he had more detailed knowledge, then that's a different point altogether, and then you come on to the question of what he did or didn't know. But at the first stage, the question is, well, what should he have understood these questions to mean? Should they have been understood as broad questions about, you know, what type of assets, what sort of classes of investments and so on were they? Then we say that Mr. Vik was entirely justified in saying we didn't understand it in those terms, because you had the sort of broad idea that it was cash and cash equivalent. What you were obviously looking for from an enforcement point of view is what assets there were where, and that's something which I can't tell you now.
Can I just be clear what the issue is? You referred to it more than once as a question of construction, which I would normally regard as a word applicable to the interpretation of a written document. This is not really a question of how the court interprets a written document. It's how Mr. Vik himself did understand it as a question of fact, isn't it?
It is.
And the more unreasonable his interpretation, the less likely it is that is how he in fact understood it. But actually what we're asking is, how did he in fact understand it?
Yes.
Rather, we're not asking, the judge was asking.
Yes. The objective analysis of what it is actually capable of meaning will inform, to some extent, the interpretation or the determination of whether Mr. Vik did in fact hold the understanding. So, to give a wild example, if somebody's first language is not English, it's entirely possible that, objectively speaking to a native English speaker, it's only capable of this construction. But to somebody whose first language...
Mr. Vik's first language was Norwegian.
Well, yes, I'm not taking that point.
But it's not suggested he didn't speak.
No. I'm not taking that point. I was simply giving it as an example of how it is possible for it to be entirely understandable that although a particular form of words doesn't objectively to a native English speaker have that meaning, a witness could be accepted as having understood it in a different way because of, for example, language difficulties. As I say, I'm not suggesting that is relevant.
No, I was just cavilling at the word construction, which doesn't seem to be entirely apposite in the circumstances.
Yes, I follow that. Yes, I follow that. The other point I should correct is that the deposition, there were
Your point really then is that we are in as good a position as the judge to assess the plausibility of what Mr Vik says he understood, to the extent that that depends on the words used in the question.
Indeed. Indeed. The one thing I wanted to clarify is that I had said that there was a reference to HSBC in the deposition. There is, but it's in the 2019 deposition.
Ah.
So the fact remains that Deutsche Bank were aware of the fact that the transfers in and out bank accounts of Beatrice were held at HSBC, because that's where the transfers from and to SHI's bank accounts took place. There are other issues. There was other issues in relation to the role of Messrs Zimmerman and Gouch, which you may have seen peripherally, but the judge was not satisfied that they were actually in existence either at the time of 2015, let alone at the time of the committal hearing, and therefore she didn't make a finding of contempt in relation to that or any order in relation to that. But they were the people through whom those as sub-agents, as it were, of HSBC, the transactions had been handled. And so we've set out in at paragraph 84 the judge's basis of our skeleton, the judge's basis of rejection of Mr Vik's professed understanding. She said it was a gloss on the transcript, holding that the objective and subjective interpretations of the asset questions advanced by Mr Vik were wholly implausible when they were read in context. Rather, she said they were broad questions which were not or not only referring to the precise assets. And we set out at paragraph 85 why there's a difficulty in relation to that. First of all, the very nature of the question that's being asked, namely pointing towards a catalogue of precisely what assets Beatrice and the Trust held at the time. If we take the judgment at paragraph 136, that there's a sort of two different approaches in a sense, because at 136 of the judgment, she says, to the extent that Mr Vik asserts that he had an honest belief in his answers because he understood the questions to refer to the precise assets rather than the class of assets which he had already answered to some degree, I reject that assertion as not in any way credible for the reasons discussed above. And so we understood her to be accepting in principle that he had already to some degree answered the questions in relation to the class of assets. And as I say, on any view, the sequence of questions that had been addressed did identify the classes of assets because, as I say, they'd identified that they were cash or cash equivalents that had been transferred in, and the intention was to maintain the status quo, and there was no intention to change anything in relation to the management of those. It is, as we say, difficult to see what else it can be suggested that Mr Vik was expected to answer if he didn't have more specific knowledge of precisely what assets the trust was invested in. And so we set it out in detail in 85 and 86. As I say, in relation to what had already been the subject of debate, what was the motive for the question, namely to facilitate enforcement, which involves the identification of specific assets rather than classes of assets, and therefore if the detail of the information which Mr Vik had was limited to broad knowledge of the types of assets, classes of assets, rather than specific assets, then it was a perfectly legitimate, sensible and appropriate response to say, no, he didn't know the answer to the specific assets rather than to the general class of assets. And at 85.5 we make the point that the breadth of the asset questions, according to the learned judge, was confirmed when Mr Vik was challenged on his initial response by reference to his role in the trust. But those essentially just put the same questions again. They said to Mr Vik, well, hold on, you had this particular role, so you must have known what the trust was invested in. But again, that points Mr Vik, if anything, towards his conclusion as to what was being asked about, namely the details of the assets, rather than these broader general questions about what was meant. So the first topic ultimately is a question of the court to determine in the context what it thinks, whether the learned judge's finding is defensible, that he must have understood those questions as referable to broad information about the asset classes and so on, if that was the information that he had, rather than Mr Vik's explanation of what his position was, namely that he understood it to be a reference to the exact assets, and if he didn't know, he couldn't help. That then takes us on to the second aspect of this element, which is what we refer to as the flawed inferential reasoning. And this goes to the question of what knowledge Mr Vik is actually supposed to have had and on what basis. And this element is, again, entirely built on inferences. There's no sort of document which demonstrates that Mr Vik had at a particular stage particular knowledge of particular assets, which would belie the evidence that he had given that he didn't have it. The inference is drawn from his role in relation to the trust, the nature or concept of the trust, the purpose of the trust, that sort of thing. And it's being said, when you take all those factors into account, you must have known what the assets were. And what we say is that if you strip away the credibility foundation and you actually say, well, I'm going to take Mr Vik's evidence and test it against the other material which might indicate that he does have greater knowledge than he says, there isn't a proper basis for rejecting his evidence to the relevant criminal standard. I mean, there has to be no reasonably possible explanation that he did, in fact, not have this precise information which he says he was being asked to provide. And what the learned judge did in paragraph, as we set out in paragraph 89, is to emphasize certain passages from Abliazov, and obviously this is how you build up your case on inferences, and it's the concept of the net that I referred to this morning, and how you close your net. And as I indicated this morning, if you undermine an element of the closing of the net, your net simply doesn't close. You don't say, well, I've got some other inferences, unless the combination of those inferences is sufficient to close the net. The proposition is not established. And that's what we explain at paragraph 92 of the skeleton argument. If any individual part of the circumstantial case relied upon is undermined, then the judge's inferential conclusion cannot stand. Hole in the net renders the whole thing unreliable. And so at paragraph 93, we then set out the 5 different elements which are said to constitute or combine to create the net, as it were, and we say that each of those is flawed. But as I've indicated, in circumstances where it has not been demonstrated that the net is closed without all 5 of those, any one of those is sufficient. And of course, it's against the background of the general credibility point that we've already made. So the first point that was advanced or relied upon by the judge was as to Mr Vik's powers as settlor of the trust. And she concludes from the powers as settlor of the trust that Mr Vik must have been involved in the management of its assets. We address that in detail at paragraphs 95 to 100, but the short point is that the terms of the deed of trust gave all power in relation to the management of the assets, not to the grantor, but to the trustees, and not to the settlor, but to the trustees. And so that in and of itself, there is a nuclear power in the sense of the power to terminate, revoke, wind up the asset. But from the point of view of the day-to-day management of the trust, that was all in the hands of the trustees and anybody that they appointed or relied upon to deal with the management. It was not a matter that was reserved to the grantor. And so that, we say, in and of itself is a bad point. The detail of that is in paragraph 99 of the skeleton by reference to the particular provisions of the trust deed, which you have in your third supplementary bundle at tab 22. And you see that rather than there being management responsibility resting upon the grantor, the management responsibility rather rests upon the trustees. Trust shall be administered by the trustees in their absolute discretion, and the trustees have the power to exercise every power and discretion not specifically granted herein in the management of the trust, as the trustees would have if they were the absolute owners thereof. So if
there doesn't seem, unless I've missed it, to be any real dispute about what the trust actually provides.
What law governs the trust?
Cayman.
Thank you.
Just double checking that, but I'm pretty sure that somebody would have shouted at me if I'd been wrong about that. I'm so sorry. Delaware.
Delaware.
Delaware. It's Article 14 on page 706.
Thank you.
And so we say, yes, there's no dispute about what the powers of the under the trust are and to whom they are provided, but the management of the trust is not one that's granted to the grantor or the settlor. That is granted to the trustees to manage the funds in accordance with their, as if they were their own, obviously subject to duties of trustees in relation to beneficiaries and so on. But it's all subject to the laws of Delaware, and I'm not going to go there.
Can I just check? What was transferred into trust was the shares in Beatrice, is that
Correct.
And does that remain the case? So the actual cash assets and cash-like assets are held by Beatrice?
The position as at 2015, according to the evidence on the transcript, was that the only asset that had been transferred into the trust was the shares of Beatrice. It was not known that there were any other assets that had been transferred in, nor that there had been any divestment.
So the evidence you referred to earlier about the assets being cash or cash-like is not actually held by the trustees themselves. It's held by Beatrice.
Yes, the directors of Beatrice,
So
who were the trustees.
Who are the directors of Beatrice? The trustees are directors of Beatrice, are they?
That was, my understanding. Again, I'll be corrected if I'm wrong. But
Right.
So that's the way the assets that are cash or cash equivalent are in Beatrice.
Yep.
They are managed by the directors of Beatrice. And I'll double check the position as
So,
to who
quite
they were.
trustees, the trustees don't actually have to do anything apart from hold the shares.
In reality, yes.
But quite directors of Beatrice, they were responsible for managing the portfolio. Yep. Thank you.
And so, or yes, for managing or for making sure that somebody manages, or
Yes.
and as I say, from the 2019 transcript, the evidence of from the 2019 deposition, the evidence was that that was something that had been handled before by HSBC and was left to HSBC. And so,
But the trust doesn't provide that the trustees will be the directors of Beatrice. It just so happens that they were, but that could have been changed. Is that right?
yes, the trust does not provide that the trustees must be the directors of Beatrice. There's nothing intrinsic in the trust linking it to Beatrice in that way.
So the trustees, as effectively shareholders of Beatrice, could have exercised their powers to appoint different people as directors if they wanted to. The shareholders of Beatrice, namely the trust, Yes.
therefore the trustees could have exercised the powers as shareholders, yes.
Yes, I see.
So, the first point, as I say, the powers as settlor of the trust doesn't provide a proper foundation for suggesting that the management of the assets should be handled by the settlor or the grantor and should be within the intimate knowledge of the grantor and the settlor rather than those who bore responsibility under the trust for that, namely the trustees. Second one was Mr Vik's perception of the role of the protector. We've dealt with that in our skeleton at paragraphs 101 to 107. And this, we say, was the approach of the judge was based upon a fundamental misunderstanding of the evidence of Mr Vik, because the paragraph 101, we identify the relevant paragraphs of the judgment. And what she did was she received Mr Vik's evidence that when asked who was looking after the interests of the trust, he answered that he was relying on Miss Asparago as protector because Mr Vik had ceased to be protector of the trust and passed on that role to Ms Asparago. And I infer, she says, that Mr Vik regarded himself as carrying out the function at least until 2015, while he held the role of protector. But again, the question is, in your capacity or job of looking after the interests of the trust, what does that involve as protector? Does that mean that from 2015, when it passed to Ms Asparago, she must be taken to have intimate knowledge of the assets that are in the trust, or, in fact, what has happened is that she is the one who's responsible then for appointing the trustees and for making sure that the relevant trustees are appointed, and in the same way as Mr Vik had performed that role, namely by the appointment of relevant trustees, the interests of the trust were looked after, not meaning, as the protector, I assumed Miss Asparago was micromanaging. But again, there is the sort of slight oddity of all of this, that nobody's actually suggested that the assets of the trust were anything other than the shares in Beatrice.
I must admit that the concept of protector of a trust is not something I'm familiar with. Maybe that others here are. Was there evidence about what the functions of a protector of a trust under Delaware law are, or indeed about the provisions in the trust deed about what the protector is supposed to do?
There was no evidence of Delaware law in relation to the expectations of Delaware law as to the role of protector. There is a provision, if your Lordship will just bear with me a moment, in page 689. There is a section on the protectors. There are 4 paragraphs dealing with it, and at B, well, A is the grantor is appointed the protector, and if the grantor resigns or ceases without appointing a successor, the grantor's spouse is appointed as successor protector. But B, the protector of the trust shall have the power to designate his or her successor as protector by an instrument signed and delivered by the protector to the independent trustee, provided, however, if the protector is the grantor, the protector shall not appoint a successor. In the event that any protector of any trust shall cease to serve, how
That's all about who the protector should be.
rather than
There's nothing in that clause anyway about what they're supposed to do.
No, that is.
At the beginning of Article 5 gives the protector power to appoint and fire trustees.
Yes, and it's in that sense that the, as it were, taking care of the trust or caring for the interests of the trustees is, we say, intended by Mr Vik in the passage of his evidence where he says, I was relying upon Mr Sparago as protector, and the when asked who was looking after the interests of the trust. And of course, the responsibility of the protector is through the appointment of trustees.
But assuming for the moment that that's the limit of the protector's formal powers over the trust to remove and appoint trustees, a protector can't sensibly exercise those powers or consider whether to exercise those powers without exercising not day-to-day micromanagement, but at least some oversight over the performance of the trustees, because one would expect if a protector is asking himself from time to time, am I happy to leave these trustees in place or should I appoint someone else? They must have at least some broad idea of how the trust is doing.
Well, the trust itself ultimately had the shares in Beatrice, and there was nothing very much from that point of view. Looking through the trust to the performance of Beatrice, then the point that was made by Mr Vik was, first of all, he was advised to distance himself from the trust, and therefore he didn't play an active role. In practice, your Lordship is postulating the theoretical manner in which a protector might perform his role. The counter to that in our particular case is how Mr Vik says he was advised he should in fact perform the role of protector in the context of the risk or the threat to the assets, namely by distancing himself from the trust in order to maximise the protection to the assets of the trust. And so one cannot, we say, simply take or may draw an inference, let alone an irresistible inference, that as protector of the trust he must have known the detail of which particular assets the trust was invested in circumstances, first of all, where he had specifically said that he was proceeding on the basis that he should distance himself from the trust. And so, again, and compounded by the position that if you understand that the assets of the trust are the shares and the investments of the company are going to be cash equivalent, and it's going to be managed as it had been before, and the assets were from a sort of custodian point of view in the hands of HSBC, and the trustees, as Mrs Vik in the 2019 deposition explains, left it to HSBC to carry on as before. In those circumstances, that combination of circumstances, why would you have expected the protector to be doing more? Whereas I can, of course, accept that in different circumstances, a protector might have taken a very active interest and not quite micromanaging, but might have been breathing down the neck of the trustees at all material times, especially if they were corporate trustees rather than friends or family.
But isn't it a fair inference that if the protector was doing his job properly, then he would need to know something about the performance of the trust and the underlying assets from time to time, because he needs to consider whether the trustees are the right people to be in charge of these significant sums, and that would be particularly so if the trustees who are appointed are people who, on the face of it, don't appear to know much about anything.
Comes back to the fact that if you've got the assets invested at a time when you hand over, and you hand over responsibility deliberately with the intention of distancing yourself from it, the answer is no, it is not surprising in those circumstances that you would not acquire or seek knowledge of the details of the performance.
Well, even if you hold assets in cash, you might well want to know whether whoever is responsible for managing that cash is getting the best available interest rate from time to time, or equivalent investment return.
That you might, or that you might not, doesn't make you guilty of a contempt. In order to establish that Mr. Vik deliberately withheld relevant information, you must be persuaded, or the judge had to have been persuaded, beyond reasonable doubt, that the only possible inference is that Mr. Vik knew all this information but declined to share it. And so, yes, one can theorize, and indeed the judge did theorize, about how protectors might operate, how this might operate, how that might operate. She was also met with some answers to some of those in relation to the desire, according to Mr. Vik, on legal advice to distance himself from the trust, and therefore the fact that he did not operate in that way. Now, is that incredible? Is that not a reasonable possibility, that that is what he did? And if that is a reasonable possibility, then, frankly, ultimately, even though one might say, well, I would have expected him to do better, I would have expected him to do differently, you cannot work from that to say, I'm absolutely persuaded that he's lying in telling me he didn't do that. And that's the difference, that's the gap, yes, which the judgment doesn't close in the net. And I say it doesn't close it in relation to any of these individually, but if you take the one we're dealing with at the moment, the powers as settlor of the trust, and Mr. Vik's perception of the role of the protector, which is a vital element to the analysis of whether the net closes, the net doesn't close. I mean, the difficulty is for if it's right that Mr. Vik was being advised, as he says he was, not to take an active role in the existence and assets and so on of the trust, then he would not be doing what one might expect other trustees to be doing. Is it not possible that that is what is in fact the position? That is too, we say, too fragile a basis upon which to seek to close the net.
Right. Is that a convenient moment?
Oh, yes, sorry.
All right. How are you doing for time? Quite well, I suspect.
I'm so sorry?
I said quite well, I suspect.
Yes, I am doing well. I would expect to be probably a maximum of an hour in the morning, trying to work to something like that, and then holding myself in reserve for reply some time for that purpose.
Very good. All right, 10:30 tomorrow.